Good afternoon, Coldwell Banker George Realty. Thank you for attending session 2 of the RPA training. We will start on page 8 under B, lead-based lead disclosures. And this is being recorded, so if you happen to have missed it, you can let your colleagues know that they can look for it on our training. Okay, so I'm going to get started. I'm going to share my screen. Okay, so I've made notes to streamline this particular process so it's not as long. I'm going to highlight the important, what I think is important in the paragraph. So we're going to start with B, lead disclosures. This is required, the lead-based paint disclosure is required for any residential properties built on or before July 1, 1978. And if that's the case, then you need to deliver car form LPD, lead-based paint disclosure to that particular buyer. C, home fire hardening and defensible space. So C and D, for any transaction where a TDS is required and the property is located in a high or very high fire zone, and the home was constructed before January 1, 2010, then the seller will deliver to buyer. It's the FHDS car form, home hardening disclosure form, FHDS. And also the statement of features, which the seller is not, that the seller may be aware that would make the home vulnerable to flying embers or wildfires. So you need to get this delivered right away because there are some points on that where that would be very interesting for the buyer. So if it's in a higher, very high fire zone, make sure you look at your TDS, your NHD report, and it'll say right on that report whether it resides in one of those fire zones. A waiver is prohibited on statutory disclosures such as TDS, lead base, and those types of disclosures. Return of the signed copy of the disclosures. The buyer should return the disclosures within the contingency period or 5 days after delivery, whichever is later. So we want to make sure as a listing agent that we are getting those disclosures out at the top of the escrow period, because you don't want to be responsible for adding more time to a contingency because we didn't deliver. Termination rights. So statutory and other disclosures, we're going to deliver them to the buyer after the offer is signed. On statutory disclosures, the buyer has 3 days after delivery in person if you hand them to them, or 5 days by mail or electronic delivery. They can rescind the offer on statutory disclosures. We could actually, with a counter, send those statutory disclosures out, but I normally just send the whole disclosure package out all at once, fairly quick. Excuse me, I'm going to stop recording.
They cannot connect. Rebecca Silva.
Okay.
Cannot connect.
Okay, I don't know because
something wrong with the link.
Where's Rhett? Okay, let me call him. My downfall is I'm not very tech savvy. See, that's what I thought. Rhett, the people can't get into the training. Something's wrong with the link. They're calling Peter. Are you here? Yeah, but are you here? Oh. Okay, what do I do to fix this? No. Okay. Do you think Harrison would know how?
Yeah.
Harrison is gonna help me. I don't know how, okay? So I'm gonna put you on speaker. From the training computer or my computer? I'm gonna put you on speaker. This is,
We need a Zoom. We need a Zoom.
I am in Zoom.
Okay,
Okay, I'm gonna get off the chair. You talk to, Harrison.
Yeah,
It seems the Zoom link is not working.
yeah.
Okay.
Okay, hold on.
Sorry. You can see on the computer.
Okay, I got the.
screen is-
I got it. I got it. No, I have the invite. I have the link already.
For Tuesday, right?
Okay, I just
Good,
I just need to. How do I send it to people? I have the link.
The link.
Uh-huh.
Or come, into the email, but the email system has to be you can email to everybody.
All right. I'm doing it right now. Oh, I don't know what's the password for the. What's the password?
PPT on the computer, you just turn it on, you don't need a password.
Well, it's asking me for a password.
It's asking for your Gmail password on CBGR marketing. Brett,
PPT marketing, the password is 1611. 1611.
It is not.
It's capital A.
Oh, okay.
Alhambra, did you get it?
Yeah, let me see. I got it.
Is you?
Yeah, hold on.
I'm sorry, Catherine.
That's all right. No, you don't have to.
No,
Things
you-
happen.
You guys come on time and then, sorry.
Things happen.
God damn it. I can't see this shit.
No hurry. PPT marketing team at gmail.com, right?
It wants me to two-factor authenticate.
Huh?
It wants me to do two-factor authentication.
Two-step verification.
Yeah. You have a passkey?
So give me the
He's
phone
not
number.
here, so I'm not savvy on pulling the
Then
link.
ask for a phone number to send you the
Yeah.
ask for the phone number or what? Or something else?
What?
So what happened to the link?
I just went in.
Yeah, I get a code, but I don't know what.
Call?
Yeah.
He said,
Out.
I don't know.
what he say? He say,
It's-
he's gonna call from the phone or
Yeah.
something, right?
Yeah, for phone. The number ends in 20.
No, 2.20, that one, I don't have that number.
Okay, well, I don't
think that's IT.
I don't know what you want me to do. I can't. That's the only way.
He sent it and then you send it
You
again.
can tablet or phone
Okay,
to
you
get
know-
a passcode.
We gotta get
Okay,
that.
Yeah.
I mean, that's what I told him yesterday, I can't do this, we need yours fixed.
Should we just do it and then record it and then just send it out? I can't get the
We gotta
two-factor.
just get it done, I'll just record it. Cause I stopped the recording,
Okay, record it?
yeah, I'm recording, I'm gonna,
No, Michelle. Harrison got the link, right?
No, I don't. I have.
no,
the link.
he
I just-
doesn't, it's not working.
I
We're
can't
just
sign
gonna,
into the email.
we're just gonna continue on.
Yeah, just continue on and then we send out the.
And then we'll send out the link later, Rhett.
Got the link the last time, right?
It's okay, we're gonna continue on because there's a couple people
Okay,
here that
fair
were on
enough.
time. Okay, all right.
All right.
Okay, thank
Okay,
you.
bye.
Bye. I don't know what he just said, but okay.
I have the link. If you know exactly who you want to send it to, I can send it, but I can't blast it because I don't have access to the email.
I mean, I can go back to my computer and play with the blast, but I think
You know, it's too late. though.
it's too late. We should
Yeah,
just
yeah,
record it.
People probably gave up already. Yeah, just continue. And then we'll just send out the.
Defensible space. Okay. Okay, I was at G, I think. Okay, termination rights. Let me go back to the recording. Zoom. Hello, Coldwell Banker George Realty. I am back and we are on G, termination rights. So statutory and other disclosures, I may have said it in the last one, but I want to make sure that this was said. You can deliver the statutory disclosures with the offer once you accept it if you wish. At that point, the buyer has 3 days after delivery in person or 5 days after delivery by mail or electronic delivery to review those statutory disclosures, only the statutory ones. And if they do not, if the buyer wants, they can rescind the offer within the time period that the buyer has been deemed to approve these disclosures. So you can send these back with your signed counteroffer or your offer. But what I like to do is I like one disclosure package. Let them review it at their leisure. Get the disclosure package out to your clients, to the buyer side at the top of escrow so that they have ample time to review everything. Number 2, the defensible space compliance. If the buyer does not agree to the terms regarding the defensible space compliance, meaning that you've provided the information on the FHDS, then the seller, after first delivering a notice to perform, the buyer may cancel based on that. Maybe they don't agree to the terms on the FHDS. Okay, so just bear that in mind. This is normal disclosure stuff. They've just carved out some of the statutory and the fire. Okay, so withholding taxes. The buyer and seller instruct escrow to withhold the applicable and required amounts to comply with federal and California withholding laws. Now, the escrow officer will direct you to provide a AS or QS. You call them and ask them to which form you should provide and get that signed and over to escrow so that they have the correct forms to not withhold the taxes. Usually when you provide those, they're not withholding taxes, but you can ask escrow. They're happy to help you on that. Now, Megan's Law database disclosure. This is really important. They've given them a website here to check. So the database is maintained by the Department of Justice. The buyer can go ahead and check the database themselves. We as agents, we do not check it for them. If they want further information regarding Megan's Law, they check the database themselves. They can put in zip codes, addresses, whatever they want, but we are not to check that for them. You can point it out to them and they can check it themselves. There is also a website on notice regarding gas and hazardous liquid transmission pipelines. So they've provided a website here where you can check this public database to seek further information regarding the location of gas or hazardous liquid transmission pipelines, if applicable in the area. Again, it's not something we check for them. You can point these 2 websites out to your buyer. So we are on K, natural and environmental hazards. You're going to deliver to the buyer the earthquake guide and environmental hazard booklet. Those should be contained in one for all residential property with 1 to 4 units and any manufactured or mobile home built before January 1, 1960. If it was built before that date, you're also going to provide the earthquake disclosure questionnaire that'll be filled out by the seller. So fully complete that if it's built before 1960 and provide the booklet. We recommend at our brokerage that even if it was built after January 1, 1960, that you do provide the booklet. because there's a lot of good information in there. And there is a receipt that they received the booklet. So even if it was built after January 1, 1960, please provide that booklet. It's just a little added protection. Condominium and planned unit development disclosures. You're going to disclose to the buyer, the seller, if the property is in a condo or planned development or other common interest development or subject to any CC&Rs. So where you're going to disclose it is either on the SPQ or the ESD. Okay, we're going to move to the next page. Okay, so I'm going to move to solar power systems. For property with any solar panels or systems, the seller shall deliver to the buyer all known information about the panels and system via CAR form, solar advisory questionnaire. If you know that there's this type of system on the property, when you take the listing, you should be asking for the contract, because sometimes the new buyer will have to qualify with that company that has the contract for that solar system. So make sure that you are getting that stuff in advance, those contracts, if that is applicable to your deal. Balconies, exterior stairways, and other elevated elements. So for a property with any building containing 3 or more dwelling units with elevated balconies, stairways, then the seller will deliver a CAR form, WBSA, wooden balcony and stairs addendum. I believe I saw that wasn't it extended to 2026?
That's right, January 1st, 2026.
So
Extended.
they've extended the inspection date to January 1, 2026. So I know we were telling you before to ask the HOAs if they have these inspection reports, but now it's been extended out. But nevertheless, if your property contains this, since it's in the contract, please provide that form. And as Peter was talking, oh, go ahead.
And also there's different kind of inspection for HOA to compare to the other regular inspection, like apartments, is different.
Okay, so there's different inspections if it's in an HOA or regular apartments. Those will be due by January 1, 2026. Okay.
Also, I have a comment on the solar systems. Most of the solar systems, they have a lien contract on the property itself. So it goes to the property. And then whoever buys the property will have the obligation to continue with the contracts.
Okay.
So you should, if they have a solar system there, you should settle with the seller as to who has the responsibility to continue the payment.
Okay, so the solar system, if it's on the property, it's generally going to be liened. You could probably find it on the preliminary title report. Make sure that you are outlining if there is a payoff on that system. Is the seller going to make the payoff, or is the buyer? And that's Peter's advice. That is good advice, because that can get kind of contentious on those types of deals if you haven't ironed all this out. And sometimes even with a paid off system, the buyer is still going to be required to buy through the solar company. I had that happen on one deal. So I'm not an expert on it, but there's a lot of ins and outs to that. So make sure you're negotiating that up front, and that you do have the contract so that your buyer can review it. As Peter addressed last week, the known material facts, you still, as a seller, even if there's not a specific question or there's not a specific disclosure addressing it, disclose any known material facts and effects affecting the property. So it's including known insurance claims within the past 5 years. And if the buyer would like permission to contact the insurer to get information about a claim, There is a form that would need to be executed by all parties. It's a car form ARC. So don't just tell them to go contact the insurance company as a listing agent. If they want to contact regarding past 5-year claims or claims, then make sure that you are filling out ARC and all parties are signing, okay? Buyer investigation of property and matters affecting the property, So the buyer has the right to inspect the property within the specified times of the contract, which is contained on the grid. They normally default to 17 days. Some buyers will cut those down to be more of an advantage when they're presenting offers. So you might see them cut down to 7 to 10 days. But at any rate, they have a right to inspect, and they're going to be doing a combination of a general home inspection, an inspection of lead-based paint, if applicable, or related hazards. They can do their termite inspection, but it does not include, that termite inspection does not include water tests of shower pans on upper level units, unless you have the consent of anybody below them. It does not include roof covering if it's located in a condo or common interest complex. You'll need to look at the HOAs if it's a standalone, but it's still in a condo or a planned unity common interest complex. They may have their own roof. You need to check on those things and see who is responsible for paying those. Sometimes even balconies in condos are parsed out to the HOA. So it's really important to review all those, help your buyer review that so they understand who's paying for what. Without the seller's consent, the buyer shall not do inspections that are invasive or destructive, nor shall they cause any inspection, very important, by any governmental building or zoning inspector or government employee unless required by law. So they can't just call a city inspector over unless it was required by law. Okay, and the seller needs to make the property available during the contingency period for the inspections, including having water, gas, electricity, pilot lights turned on. All of that must be on for the buyer's inspection. The buyer will complete the investigation and satisfy themselves as a condition of that property. So the buyer shall provide the seller the investigation reports, any of the investigation reports they have, at no cost to the seller, except the appraisal, unless it's received in connection with an FHA or VA loan. So unless a buyer is asking you to reduce the price or something like that, I know this is an inspection, but I'll just add this here, due to an appraisal shortage, then they would give you the appraisal report. They can't just ask you to do it and not have any evidence. But as a normal routine, that is not a report that the listing agent will get for the seller. Buyer needs to keep the property free of liens and repair any damage from investigation. Now, what does that mean? What if the buyer was authorized by the seller to do some work on the property prior to close? My opinion, I probably don't recommend it. However, the seller can file a notice of non-responsibility car form NNR and post that. Do you have any comment on that, Peter?
No.
Okay. So you can post that. I really don't recommend that work is being done on a property when somebody doesn't, isn't on title yet. Okay, title investing. The buyer shall be provided with the preliminary title report. The buyer needs to review in its entirety that prelim. There are blue links on every prelim, so you're going to click those links. If you don't have a blue linked preliminary title report, ask escrow to get it for you, or call the title officer to get a clickable link. And the reason why is there's underlining documents. You can just click those links and print them so that you have a full prelim. So you're going to make sure you do that with your buyer. Make sure it's a linked copy that you're sending to them where they can click the links if they desire. But you want to recommend to them that they do that. So if escrow requests information from the seller regarding information to clear some aspects of the title, the seller is to provide that to escrow within 7 days of request. And the seller also needs to disclose to the buyer any known material facts that may affect title, even if it's not shown on the preliminary title report. So they still have reporting responsibility to the buyer. I'll go over E briefly. This is handled through escrow, but we need to know a little bit about it. Let's see. E, if the buyer purchases a property of at least 300 and the purchase is made without a bank loan or similar financing, which is very common around here, a geographic targeting order called a GTO is issued by the Financial Crimes and Enforcement Network. And it will require that the title company collects certain information from the buyer, and the buyer agrees to cooperate with this collection of information. Okay. So the grant deed will be provided to the buyer at close of escrow. And we get a lot of questions. I've gotten them. They'll say, how should I take title? Well, that's not in our lane. So they should seek professional and legal consulting to answer that question. We never want to answer those questions, even though many times escrow will give a sheet showing how, different ways to take title. We don't want to be advising. That's not, something that we do in our job. Okay. So 14 is the time periods, removal of contingencies and cancellation rights. The seller usually has 7 days after acceptance unless otherwise negotiated to deliver the documents, all the seller disclosures. The buyer will review the documents. The buyer has the time specified in the grid. It's usually, they have 17 days to review. Seller has 17 days, 7 days to turn them over to the buyer. They're going to review all of the applicable disclosures, and the buyer may, within the time specified, they're going to do, oh, excuse me, I'm running over myself. And they're also going to do the inspection on the property. So the buyer, within the time specified, on number 2, they can ask the seller to make repairs after they have done a thorough inspection of the property on CAR form RR request for repair. However, the seller has no obligation to respond to the buyer's request. If the buyer does not agree or respond, the buyer is not contractually entitled to have the repairs or other requests made and may only cancel based on the contingencies in the agreement. Normally, as a courtesy to other agents, even if they send a request for repair and the seller does not want to perform any of those items, we usually will answer them. But the seller is not required to answer, nor do they need to make the repairs. Now, if you have an FHA or VA loan, remember last week we said that FHA and VA may have some required repairs, and their appraiser can also call out repairs like chip paint, broken window, things of that nature. Even at that, the seller does not have to agree on an FHA or VA. However, that may impact the buyer from getting that loan. So after that, then the buyer has the time specified in each contingency to deliver a contingency removal or cancellation of the contract if they're canceling due to a contingency. So the seller right and buyer right to cancel, and this goes both ways. So the seller right to cancel, if the buyer does not remove the contingencies within the time specified in this agreement, then the seller's going to deliver a notice to perform, CAR form NBP, and they need to wait the 2 days, and then they may cancel the agreement, and the seller at that point needs to authorize the return of the buyer's deposit, less any costs incurred. Maybe the buyer has some costs in escrow that they need to clean up. So seller right to cancel, buyer contract obligations. Upon delivery to a buyer of a notice to perform, the seller may cancel this agreement if the buyer does not take the action, take an action such as also depositing initial funds. If you find out they have not deposited the initial funds and it's beyond the days in the contract, make sure you immediately go to notice to perform on that. The seller has the right to cancel as well if the buyer, this is interesting, does not provide updated contact information for the buyer's lender. So if you got into a deal and then the buyer switched around on you with the lender, which they can do, but they haven't provided you contact information, you can demand that because the seller and their authorized agent has a right to check on that. Okay. So that's something interesting that's embedded in the contract. So buyer right to cancel is the same, works the same way as for the seller. You have to do notice to performs, etc. So 14E, notice to buyer or seller to perform. The notice to the buyer or seller to perform needs to be in writing, of course, signed by the applicable party and given to the party at least 2 days after delivery of notice to perform. This notice may not be delivered any earlier than 2 days prior to performance day. So if you wanted to get out ahead, if you're having problems, you feel in an escrow, you want to get out ahead of a contingency and you want to make sure they know you're on top of it, you may send a notice to perform 2 days ahead of that contingency removal date if you're having other problems. Normally we don't do that, but it depends on how your deal's operating. So removal of buyer contingencies. If they remove contingencies, the buyer is deemed to completed all their investigations and review of disclosures, reports documented. The buyer will further assume any liability and responsibility for non-delivery of reports or disclosures outside of the seller's control. I don't know what that could be. I'm thinking maybe city check or something like that. And the removal of seller contingencies is the same as above on the buyer contingencies. So 14G, I've only seen this used probably 2 times. We don't have to use it a lot, thank goodness, but demand to close escrow before either party may cancel this agreement. The party needs to deliver a demand to close, a CAR form DCE, giving the other party at least 3 days after delivery to close escrow. So this one's a little different. It's not 2 days. So just remember that's 3 days on a demand to close escrow. 14H, effective a cancellation on deposit. If the buyer or seller gives written notice of cancellation pursuant to their rights under this agreement, the parties agree to sign and deliver mutual instructions to cancel. So it can be at first a single party cancellation, right? And then there's going to be the second page of that form is going to say the disposition of the deposit. So you can get that done on a single party, then you will send it to escrow. They are going to create an amendment where all parties sign. Now, if a party may be subject to civil penalty of up to $1,000 if they're just refusing to sign, okay, for no reason. So repairs. So repairs, if they're applicable, shall be completed prior to COE if you agree to them during the inspection period, and they may be completed by the seller as long as they are with like material and in a skilled manner. And regardless of who does the repairs, the seller shall provide receipts or invoices of such repairs, the date completed, and give those to the buyer prior to the final verification of property. Because when you go in verifying the property 5 days before close of escrow or earlier, you're going to want to make sure that the repairs that were agreed upon are complete. And one way to check that is to have the invoices or receipts. Number 16, final verification of condition. The buyer does have a right to make a final verification of the property. It's not a contingency. They are solely confirming that the property has been maintained in the same manner as when they made the offer and went into escrow, and that the agreed repairs are complete. So that's something you need those receipts prior to walking through at the end. 17, prorations of property taxes. So I'm not going to go a lot into this. The escrow holder will handle the prorations. However, one thing that you need to be doing is, I would say, a week in advance, they can put together an estimated closing statement. So whoever you are representing, whether it be the seller or buyer, make sure that you're getting an estimated closing statement so they can begin reviewing it prior to close. You don't want questions on the last day. You want to make sure you're getting an estimated at least a week in advance and giving it to your party you represent so they can review it. Tax and utility bills after close of escrow are handled directly between the buyer and seller. So 18, brokers and agent compensation. The seller or buyer agree to pay compensation in accordance with written agreement. So buyer representation, this is the new thing that they added, that the buyer affirms that there was a written agreement in place. At the time of the offer, it's valid and provides for compensation at no less than stated in the agreement. If any of these statements are not true, then the seller has no obligation to pay compensation to the buyer's agent. So it's pretty important. Scope of duty. So there's several things in here, but I will just highlight a couple and then you can read this in more detail on your own. So buyer and seller acknowledge that the agents do not decide purchase price nor guarantee the property condition. We're not responsible for providing any legal or tax advice. And I recommend that you read this. This is a good paragraph for agents to read. It tells what our responsibilities are. Okay, and what we're not responsible for. We don't give legal or tax advice unless we're a lawyer or a CPA. Okay, so number 19, joint escrow instructions. Certain paragraphs that they have outlined in this paragraph here are incorporated into the joint escrow instructions. Okay, so they're taking care of that. These are all incorporated into the escrow instructions. And generally, they're not going to list this out. They're just going to attach the agreement to the escrow instructions. Okay. So 19C, I'm going to drop to here, copies, statement of information, tax withholding. Instructions, a copy of this agreement, including all addenda, is delivered to escrow within 3 days after acceptance. So you don't have to do it the hot minute you get it, but you have 3 days after acceptance to deliver everything to escrow. Broker compensation on D, the escrow holder will provide the buyer with a closing statement disclosing compensation paid by the buyer, and escrow shall provide seller with a closing statement, including the amount of compensation paid to the seller's agent and, if applicable, the buyer's agent. So this is why I think it's really important to get estimated closing statements a week ahead of time. You want to check those figures as well for whoever you're representing. Invoices, if there are any approved expenses that you were approved to make by the parties, you should provide an invoice to escrow as soon as received or in sufficient time for them to close escrow. Sometimes there could be expenses like you bought an extra carbon monoxide reader, something like that. Make sure you get it signed off by the seller and sent into escrow for payment. Verification of deposit. The escrow will notify each agent if the buyer's deposit is not made or not good at the time of deposit. And they will also notify you if either party is instructing escrow to cancel escrow. Okay. 19G, delivery of amendments. You're to deliver any amendments within 3 days after mutual execution. So you do have time to get those over. Selection of service providers. We do not, as agents, guarantee the performance of any vendor or whether the agent, whether we referred them or not to the client. The parties may select and probably should select any vendor that they wish to select for things that need to be done. This is important on 21 because we get questions about this all the time after escrow closes. So the buyer is acknowledging, there's other things in this paragraph, but the important point is they're acknowledging that there are pictures, videos, perhaps floor plans, or other information about the property on the MLS, right? And it will not be removed by close of escrow. So California Civil Code, which I just learned this today, I didn't realize it was a civil code, does require the MLS to maintain images and information for at least 3 years. And as a result, that may be circulated on the MLS. You get people that are upset that there's still pictures of the interior of a property, but it's in 21 and you can point that out to them.
And you have to stay on it for 3 years.
Yeah, that's what the civil code says. Now, I do know that the board will assist you further if all parties are in agreement of maybe removing some photos.
Yeah.
But that's something you would have to check, okay?
Mhm.
But we probably once every couple of months get a call on this. Attorney fees. I'm sorry, non-prevailing party pays reasonable attorney fees. If something goes sideways on this. Assignment and nomination. So the buyer does have a right. This defaults to 17 days in the grid. You can assign, excuse me, the contract. Sorry. But the buyer has the right to assign the agreement to their own trust or wholly owned entity of the buyers that was in existence at time of such agreement. So if that's the case, they've already signed everything. Outside of that, it's required that the seller provide written consent for the assignment. Now, you do have 17 days in the agreement to notify the seller that you're doing an assignment. If you do an assignment, then you may check and with us, because we're going to want everything re-signed by the person that the contract's being assigned to. Okay. That doesn't happen a lot. Excuse me, I'm going to take a drink of water. Sorry.
Okay.
25, property is sold in compliance with federal, state, and local anti-discrimination laws. So definitions, I'm going to let you read the definitions on your own, which are provided right here. Liquidated damages. Now, this paragraph here, that is up to the parties if they want to sign this. But if it's not executed or initialed by both parties, it's not in the contract. So make sure if you're expecting that to be initialed as a buyer's agent that you get the seller's initials back. Sometimes counters are just sent and you don't have the whole contract. Mediation is automatically built in here. Arbitration of disputes. Again, it takes both parties to make this so in the contract. So if the buyer's expecting that, make sure if the seller only returned a counteroffer and not the whole contract, that you check that. You say, can you send me back that page with those initials? Because if only one party signed, those two won't apply, okay?
Before you decide whether you want to maintain the mediation and arbitration, you should really talk to the buyer and the seller. Whether it's beneficial for them to stipulate the mediation and arbitration. Arbitration may not be cheap at all. And nowadays it takes about at least a year to do the arbitration. Yeah, arbitration is very expensive because you have to pay maybe up to $700 per hour for the entire judge to be the arbitrator. My girl.
So everybody, make sure that you heed Peter's advice. Don't just blindly say sign here, sign here.
Yeah.
Make sure the parties understand, because arbitration can run $700 to $800 per hour. It's extremely expensive. So you want to make sure that you're explaining some and not just doing the sign here.
Because if you mandate the mediation and arbitration, you have to go through the mediation and arbitration first before you can sue anybody.
Wow. That is, yeah, that's a good point. So let's not just be pointing and saying initial here when we don't really understand it ourselves.
Yeah.
Make sure that you have some understanding. If you don't come in and talk, I'd say to me, I'll try to understand it better, but probably Peter could advise a little more on that, but I will do my level best to understand it as well, more clearly. Okay? So fair appraisal, notice, the appraisal of the property shall be unbiased, objective, and not influenced by improper or illegal considerations. You can read the whole paragraph. The crux of it is if the parties do suspect there was a violation, there's a phone number provided in here and a website for the parties to call if they wish, and it's to the Bureau of Real Estate Appraisers, and they can get some clarity and talk to somebody there about what they suspect the violation is. So they give you the phone number and a website. And if I were advising agents, I would say let the party that thinks there's a violation do the calling and or email the website. We should not be doing that for them. We can point out this paragraph to them though. So terms and conditions of the offer. If liquidated damage and arbitration of dispute paragraph are incorporated, they must be initialed by all parties. If at least one but not all parties initial, then you would need to have a counteroffer until agreement is reached on initialing those paragraphs or not. And the seller has a right to continue to offer the property for sale and to accept any other offer at any time prior to notification of acceptance and to market the property for backup offers for acceptance. So you can read this paragraph in its entirety. That's just a snippet of it. Time is of the essence. All understandings between the parties are incorporated into this agreement. And then if initialed, of course, liquidated damage and arbitration of disputes, all amendments must be done in writing. Just one thing about liquidated damage, remember for residential, it's 3% max. So on commercial, there is not a maximum. Now we're going to go to 32. Expiration of the offer does default to 3 days in the grid. And it says in here that the seller has no obligation to respond to an offer made. However, each agent, I'm going to advise that you have the seller initial and date on page 16 that the offer was rejected and on what date, and that the seller does not want to make a counteroffer. You want that in backup for your file, regardless of anything else. I always, even if you have 10 offers, please get that page initialed so that if you were ever questioned, you have the initials and the date that it was presented and that the seller elected to make no counter. You want to make sure you do that. It's really important. So expiration of offer, we went over that. If it's an entity buyer, you're going to click the box here and you're going to write in the entity name, full entity name here, who are the legal and authorized signers. Don't worry, if it's not on the offer, we can do another form to bring that in. So you don't have to worry initially. We'll get that brought in on an RCSD if it wasn't in here initially. So it's the same on both sides. Seller and buyer each have an entity. One thing I want to make sure, when you are acceptance of an offer, you want to make sure if it's subject to, it's subject to. I like to highlight it. I don't want to just check it so they can't see it. You want to highlight it and, you know, subject to the attached either multiple counteroffer or seller counteroffer. Okay, so that is the end of the agreement. I want to show you back here. You're going to fill all this out here. I would try as a buyer's agent to fill everything out, even if I'm not one of the firms. Try to get all the license numbers in and all of that. Down here is where I'm talking about. Make sure if you are not going to present a counteroffer to the buyer, please have this initialed. It says the agent or the seller may initial. I prefer a seller's initial. I really don't want to initial that. and you're gonna put the date here that the firm presented the offer to the seller, okay? So this is a very important box because people may challenge something later, you don't know, but at least you'll have this on file. Any offers not accepted, please keep them in your file. Do not destroy them. Do not get rid of them. Let's keep them. And that goes with any offers that you do, any lease applications that didn't go through. Keep all those things on file.
Yeah, it is very important because, even for the deals that you didn't consummate, you should keep track of your paperwork. Because later on, the same, tenant or buyer will come back and sue you, and then you have nothing to prove. And you're in big trouble.
Yeah.
We have a case just like that now. There are no proof of transaction details between the tenant and the agent. And now the agent had nothing to prove to the investigation bureau. And, I don't know what's going to happen, but, that's very sad.
They don't have a copy of it here?
They don't have it coming in the sky, they never turn it into the sky slope. And she said that, well, since this deal is not consummated, I don't need to keep the copy. That is not true.
Bringing up Sky Slope, everybody, if you have offers that weren't accepted, you can load those up in the document section of Sky Slope, and you're not going to be splitting them out. At least the brokerage will have copies of those offers that you did not accept. So please make sure you're scanning those in. You can do it in one full stack, and then you'll just leave it in the document section of Sky Slope. So we also have record.
Yeah, and
All the offers in one document?
Yeah, the ones that weren't accepted, I mean, you could split it up, but that would take a lot of time.
Yeah.
But you could take a stack and you could just write 1, 2, 3, 4, 5 on the beginning of each offer, right? Take a stack, scan it, put it in the document section of Sky Slope.
What if we sign the counteroffer and then they sign the acceptance of that counteroffer, but then we don't want to accept the counteroffer? Do we still have to click that box, or is there one on the counteroffer?
No, if you sent a counter offer and then what?
And then they signed accepting the terms, and
Yes,
then they sent it back, but we said, hey, we're going with a different offer.
multiple, right?
Yeah.
Yeah. For me personally, I would have the seller sign that box and the date. Now, do you have to give it to the other agent? No. Would it be nice to have on our file? Yes. Because that gives you evidence that you did your duty. You presented it. Because we have heard scraps where people will say, you didn't present my offer, right? But if you're on it and you already have your initials and date, you have it. Yeah. But you can just simply 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, load them into the document section. It's going to be one big stack and leave it alone. Don't split it. And then we have it. Okay. Any other questions or comments? Okay. Thank you all for listening to this recording of the second session of the RPA training. We will provide training once a month on Tuesdays. And we will next up be doing how to operate as a leasing agent for residential. Right.
okay.
Yeah. Okay. Thank you all for attending, and we'll see you again.